Hello everyone, I'm Elisabetta Carone, and with my colleague Rugiada Colò, we made a presentation about the Charter of Fundamental Rights of the European Union with a focus on the respect of freedom of religion and belief. So in my part of the presentation, I'm going to look at the European Charter of Fundamental Rights in general, so its context, its content, the articles on the freedom of religion, and its proclamation and entry into force. I'm also going to analyze the Charter in the European Union treaties, and I'm also going to give an overview on the European policies on human rights and freedom of religion in general. To begin, it's important to say that the protection of fundamental rights is one of the basic tenets of the EU law. However, for a long time, the European treaties did not incorporate a written list of these rights, containing only a reference to the European Convention for the Protection of Human Rights and Fundamental Freedoms. Treaties also refer to those fundamental rights which result from the constitutional traditions common to the member states as general principles of community law. Moreover, through its case law, the Court of Justice of the European Union has contributed greatly over time to the development of and respect for fundamental rights. But then, following the adoption of the Treaty of Lisbon in the late 2009, the situation has changed significantly as the European Union has a Charter of Fundamental Rights that is now legally binding. So the Charter of Fundamental Rights of the European Union sets out the basic rights that must be respected by the European Union and its member states when implementing EU law. The Charter of Fundamental Rights is divided into 7 titles, 6 of which are devoted to listing specific types of rights, while the last one clarifies the scope of the application of the Charter and also the principles governing its interpretation. One significant characteristic of the Charter is its innovative grouping of rights, whereby it abandons the traditional distinctions between, on the one hand, civil and political rights, and on the other hand, economic and social rights. At the same time, the Charter makes a clear distinction between rights and principles. The latter, according to Article 52, paragraph 5, are to be implemented through the additional legislation and only became significant for the courts in cases involving interpretation and legality of such laws. So, as I say, there are 6 titles. They are dignity, freedoms, equality, solidarity, citizens' right, and justice. The first title, the one about dignity, upholds the right to human dignity, life, and integrity of the person, and reaffirms the prohibition against torture and slavery. Then the second title, the one about freedoms, upholds the right to liberty and respect for private and family life, the right to marry and to found a family, and the rights to freedom of thought, conscience, and religion, expression, and assembly. It also affirms the right to education, work, property, and asylum. The third title, the one about equality, reaffirms the principle of equality and non-discrimination, as well as the respect for cultural, religious, and linguistic diversity. It also grants specific protection to the rights of children, the elderly, and also persons with disabilities. Title 4, on solidarity, it ensures the protection for the rights of workers, including the rights to collective bargaining and action to fair and just working conditions. It also recognizes additional rights and principles such as the entitlement to social security, the right of access to healthcare, and the principle of environmental and consumer protection. The title number 5, the one about citizens' rights, lists the right of the citizens of the Union, the right to vote and to stand as a candidate in elections to the European Parliament and also in municipal elections, the right of good administration and the right to petition, to have access to documents, to diplomatic protection, and to freedom of movement and of residence. Lastly, the title Number 6, the one about justice, reaffirms the right to an effective remedy and a fair trial, right of defense, the principle of legality and proportionality of criminal offenses, and the right to protection against double jeopardy. The Charter is very innovative in explicitly addressing modern issues such as disability and, for example, age, but also sexual orientation discrimination, as well as prohibiting reproductive human cloning. However, its primary value lies in affirming the importance of fundamental rights within the EU legal framework. It emphasizes the Union as a community founded on rights and values, with citizens' fundamental rights as its main core. What is striking about this text is its modernity and its willingness to protect rights of a very diverse nature, some belonging to several generations ago, from the Age of Enlightenment and other from the last 2 decades. Title 2 defines, as we have seen, a whole range of rights and freedoms such as freedom of thought, conscience, religion, expression, information, assembly, association, which are traditional freedoms that have been recognized for several centuries in the EU member states. The articles that interest us in this presentation are Article 10 on freedom of thought, conscience, and religion, Article 14 on right to education, Article 21 on non-discrimination, and Article 22 on cultural, religious, and linguistic diversity. So, Article 10 states that everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change religion or belief, and freedom, either alone or in a community with others, and in public or in private, to manifest religion or belief in worship, teaching, practice, and observance. Then we have Article 14 on the right to education. So in the first paragraph, this article states that everyone has the right to education and to have access to vocational and continuing training. But the part that interests us is part 3, where it is stated that parents have the right to ensure the education and teaching of their children in conformity with their religious, philosophical, and pedagogical convictions. Then we have Article 21 on non-discrimination, which states that any discrimination, including discrimination based on grounds such as religion or belief, shall be prohibited. And then, lastly, we have Article 22 on cultural, religious, and linguistic diversity, which states that the Union shall respect cultural, religious, and linguistic diversity. It's important to have a look on which institution issued the document, when, and why. So we can say that the Charter was solemnly proclaimed by the European Parliament, the Council, and the Commission in Nice in 2000, and it was proclaimed again after being amended in 2007. However, the solemn proclamation did not make the Charter legally binding, and the Charter remained a mere declaration of rights until the adoption of the Treaty of Lisbon in 2009. It became legally binding on the 1st December of 2009, and since then, Article 6, paragraph 1 of the Treaty on European Union now provides that the Union recognizes the rights, freedoms, and principles set out in the Charter of Fundamental Rights of the European Union, which shall have the same legal value as the treaties. The Charter constitutes primary EU law. It serves as a parameter for examining the validity of secondary EU legislation and also of national measures. So in this part of the presentation, we're going to have a look on fundamental rights and freedom of religion in the European Union. So we'll look at how human rights are listed in the treaties, but also I'm going to give you an overview on the European policies on human rights with a particular focus on freedom of religion. First of all, regarding the treaties, the most important article is Article 2 in the Treaty on European Union, which provides that the Union is based on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. Article 6 of the Treaty of the European Union provides, among other things, that the Union recognizes the rights, freedoms, and principles set out in the Charter of Fundamental Rights of the European Union of 12 December 2007, which shall have the same legal value as the treaties. Also, a reference to human rights and fundamental freedoms can also be found in the provision of the Union External Action, Article 21 of the Treaty of European Union, and then Article 67 of the Treaty of the Functioning of the European Union provides that the Union should constitute an area of freedom, security, and justice, with respect for fundamental rights and the different legal system and traditions of the member states. In order to give an overview of the European policies on human rights and freedom of religion, I'm going to start with the strategic framework on human rights and democracy. In 2012, the Council adopted the strategic framework, which came with an action plan for its implementation. The framework outlines in general the principles, objectives, and priorities to enhance the effectiveness and coherence of European Union policy over the next 10 years. And this principle include integrating human rights into all European Union policies as a common thread. As we can see in the slide, it states that the EU will promote religion and belief and fight discrimination in all forms. It also contains, in the action plan, a part completely dedicated to freedom of religion and belief. Last action plan that was adopted was the one of 2020. It was the third action plan for human rights and democracy adopted by the Council. And it set out the ambitions and priorities for the period 2020-2024. And it was organized around 5 main areas of intervention, containing, for example, protecting and empowering individuals, promoting a global system for human rights and democracy, and so on. Here, as we can see in the slide, there is a part dedicated to step up action to combat all forms of discrimination on any ground, also religion or belief. There is also this part that is dedicated to promoting and supporting the right for individuals to have religion, to hold a belief or not to believe, to manifest, to change one's religion, and to do so without the fear of violence or persecution. Another important document to analyze is the thematic guidelines on human rights. The Council adopted a series of thematic guidelines on human rights, which provide practical instructions for EU representation worldwide regarding areas of action, such as, for example, actions against the death penalty, rights of the child, actions against torture or other cruel treatments, but also the promotion of freedom of religion or belief. Moreover, it's also important to see what happens in the member states. The EU's country-specific human rights and democracy strategies follow, in general, a bottom-up approach aimed at integrating the EU guidelines and priorities on human rights into a single, coherent policy document. Moreover, there is also a robust mechanism of conditionality, which has been established for enlargement countries before joining the EU. And these countries must develop stable institutions ensuring democracy, the rule of law, and also human rights and the respect and protection of minorities, a process that is actively supported by the European Union. We also have the Neighborhood Development and International Cooperation Instrument of Global Europe, which is a thematic program on human rights and democracy. It primarily provides support and protection to civil society actors promoting human rights and democracy. An important feature of this instrument is that the consent of the partner country's government is not required. This thematic program includes religion in the areas of cooperation for the geographic programs and areas of intervention for the thematic programs, as we can see in the slide. Then we also have Council regulation on measures against serious human rights violation and abuses. In December 2020, the Council adopted a regulation establishing a global human rights sanction regime, which allows the European Union to take targeted measures against individuals, entities, and organizations, including state and non-state actors, which are responsible for serious human rights violations and abuses worldwide, including violations or abuses of freedom of belief, or involved in or associated with such acts. Since October 2023, the Council has imposed restrictive measures, asset freezes, and, if necessary, travel bans on 67 individuals and 20 entities. Lastly, there is an annual report on human rights and democracy worldwide, which is prepared by the High Representative of the Union of Foreign Affairs and Security Policy and Vice President of the European Commission. And it is adopted by the Council, which provides an overview of the European rights situation globally and the Union's actions in this area throughout the year. In the 2023 report, which was the last one that was published, the European Parliament expressed concern about violations of freedom of thought, religion, and belief, condemning hate crimes and discrimination against religious minorities. It advocated for protection of these rights, promoting interfaith dialogue, and integrating the special envoy for freedom of religion or belief into EU structures. It also condemned all forms of discrimination, including racism, xenophobia, and religious persecution, emphasizing the need for intersectional approach.
Hello, everyone. My name is Rugiada. First of all, I want to thank Elisabetta for the first part of the presentation, and I will now focus on the Charter from a more legal perspective, tackling the adoption of the Charter, the scope of application of the Charter, and its interpretation. And on the second part, we will focus on the Charter's recognition of religious freedom. So we'll be looking at the principle of neutrality and the definition of religious freedom, the expression of religious freedom in the private sphere, and later on in the public sphere. Now, regarding the Charter from a legal perspective, we have to start by talking about the adoption of the Charter. So, as we know, for the past 70 years, the member states of the EU have been converging not only in the economic field, but also in the political field, in the field of fundamental values, principles, and rights. And for this reason, in 1999, the European Council, formed by the heads of state and the governments of the member states, met in Cologne to develop a charter for the protection of fundamental rights within the EU. So the charter was adopted by a convention under the form of an interinstitutional agreement between the European Council, the European Parliament, and the European Commission. And it was proclaimed in late December 2000 by the Treaty of Nice. However, this interinstitutional agreement had the disadvantage of being only partially binding, because although it was binding for EU institutions, it was not binding for member states. So the idea was for the Charter to gain binding institution with the treaty establishing a constitution for Europe. However, this treaty, as we know, failed, was rejected in 2004 by the Dutch and the French. So the question arose as to what would become of the Charter. So the Treaty of Lisbon that came into force in 2009 settled the issue, and it affirmed that although the Charter does not form part of the actual body of the treaties, nor of one of their annexed protocols, Article 6, Paragraph 1 of the Treaty on the EU recognizes the Charter as having the same legal value as the treaties. So by doing this, first of all, it affirms its binding nature, and second of all, it recognizes it as a primary binding source. Now, the application of the Charter, however, has a differentiation whether it's applying to EU institutions or EU member states. And it's the Article 51 of the Charter that expressly refers to this, stating that the provisions of these charters are addressed, although in my opinion, the article should have said are binding, to the institutions and bodies of the Union with due regard for the principle of subsidiarity, and to the member states only when they are implementing union law. So here the Charter makes a distinction between, on one hand, its application to institutions and bodies of the EU without restriction, so notably when adopting secondary legislation and concluding international treaties. And the second case, it's when it's being applied to member states, but only when they're implementing union law. So this formula has been discussed at length, and it was actually the result of a compromise between the member states. On one hand, some member states did not want to be obliged to respect the charter because they felt like they were already respecting the fundamental rights of their constitutions and of the European Convention on Human Rights. So why add a new source of obligation? And on the other hand, there were other member states far more protective and more in favor of EU integration that indicated that it would be better to impose compliance with the provisions of this charter in the same way as on EU institutions, because actually member states are the main players of the European Union, and therefore there was no need to have two separate regimes. However, the difficulty lies in defining this formula only when they're implementing union law. What does it mean? And there was a great deal of ambiguity on this point, and there were two main opposing theses. There was a restrictive thesis that affirmed that the implementation of union law relates exclusively to the adoption by member states of measures implementing EU regulations or transposing EU directives. And under these conditions, member states agreed to be bound by the charter when they took such measures, which had to comply with the fundamental rights enshrined in the charter. On the other hand, there was the extensive thesis affirming that the charter covered all cases in which member states act within the scope of EU law, so by adopting an act that falls within the scope of EU law, and this considerably extended the scope of the application of the charter. And it was up to the Court of Justice of the EU as the main interpreter of EU law and EU treaties and acts. And she took a decision, a ruling in 2013, in which the court stated that when a right enshrined in the treaties is implemented by a member state, whether or not it respects the treaties, then the charter can be invoked. So after talking about the application of the charter, we have to talk about the interpretation. Once the charter can be applied, how can it be interpreted? And the scope of this interpretation is guaranteed by Article 52 of the charter. There are two important paragraphs. The first one deals with the possibility to limit these fundamental rights, but only when necessary and when they these limitations genuinely meet objectives of recognized general interest, and the limitations must be subject to the principle of proportionality. And then the third paragraph affirms that the interpretation of the provisions of the Court of Justice of the EU must be aligned with those provided by the European Convention. So basically, EU jurisprudence must comply with the European Convention jurisprudence. So now moving on to the link between EU law and religious freedom. We know that religion can lead to certain practices like certain types of clothing, eating customs and habits, prayers, different kinds of working days. And these practices differ from one religion to another. And these behaviors must be taken into account by the law like any other act. So in order to analyze how the freedom of belief, of conscience, of religion are protected by the Charter, we need to look at the interferences between EU law and religion, and more specifically at how EU law takes this freedom into account. So first of all, we can start by defining the principle of neutrality and religious freedom. So the principle of secularism is today considered sort of like a marker of the identity of what is truly a democratic society, because it is the dominant principle that is present in most constitutions of, actually in all the constitutions of the member states of the EU, as we can see in this table. And this principle of neutrality, of secularism, actually has several implications. First of all, it implies the neutrality of the state with regards to religions. However, this neutrality must be able to integrate respect for religions and for freedom of religion, which is protected by the Charter and the Constitution. And it also implies religious pluralism. So, for example, we know that some religious signs could be considered too ostentatious when worn in places where secularism must prevail, like, for example, in public spaces. So in this case, these signs could be considered as an infringement to the principle of secularism. So on one hand, individuals have a freedom of thought, conscience, and religion that must be respected. But on the other hand, this freedom can conflict with other rights and other freedoms. So it is up to the judge to resolve this conflict by giving precedence to one freedom or one right over the other. Now, regarding the definition of religious freedom, it doesn't expressly appear in the Charter of Fundamental Rights, but the Court of Justice of the EU provides us with a definition of this freedom. And the court, in a ruling of 2017, affirms that this freedom has two dimensions. It has a forum internum, which includes the faith of an individual as such, and a forum externum, which is the practice and the manifestation of that religion, including in public spaces. So what's interesting here is to see that whereas the forum internum cannot be limited, the forum externum can be limited, of course, in accordance with the law. And this is why it's important to study the expression of freedom of religion, both in the private sphere and in the public sphere. So starting by the private sphere, like we said, one freedom can be limited in the name of another. So it's a question of conciliation. And one example is the right to receive religious instruction. So to make this right effective, the state finances private religious establishments, notably by paying teachers. So to respect the freedom of religion and the religious character of the establishment, teachers' freedoms of expression may be restricted to ensure that they respect the establishment's religious convictions. So here we have two freedoms that are reconciled. On one hand, freedom of religion, and on the other hand, freedom of expression and also freedom of conscience. So for example, we can ask ourselves, are some types of clothing or other religious practices allowed in the workplace, or can the company, a private company, ban some of these practices? So this is a question that was answered firstly by the French Cour de Cassation in a ruling of 2014, which was then confirmed twice by two rulings of the EU Court of Justice in 2017. So in the French ruling, a woman refused to comply with the employer's request not to wear a conspicuous religious symbol at work, which in that case was the Islamic veil in a nursery, and she was fired for it. However, the court established the principle that a private company may introduce restrictions on an employee's freedom to manifest their religious beliefs if they are justified by the nature of the task to be performed and proportionate to the aim pursued. And therefore, in this case, the court confirmed that the employee's dismissal for serious misconduct was justified. And this was actually confirmed twice, like I was saying, by the EU Court of Justice in 2017, by two rulings in which the four following principles are affirmed. First of all, the prohibition on wearing a political or religious symbol provided by a company's internal regulation does not in itself constitute a violation of the principle of non-discrimination on the grounds of religion or belief. However, it is important that this prohibition should not constitute an indirect discrimination within the meaning of EU law by in reality targeting only believers of a single religion. So to this end, the ban imposed on the company's relations with its customers must obey precise objectives and respect the principle of proportionality by being appropriate and necessary. And lastly, this is a test and appreciation that must be done in concreto by the national court of the member state, in front of which the case is being brought. So moving on now to the expression of freedom of religion in the public sphere. Here we can look at two main themes: public order and public service. Regarding public order, this debate with freedom of religion became particularly relevant, especially in France, after the terrorist attacks at the beginning and at the end of 2015. So some bylaws were issued by certain municipalities to prohibit the wearing of the burkini, to avoid not knowing who people were in presence of. And there was a ruling of the Conseil d'État of 2016, a ruling that was later named burkini, in which the Conseil d'État affirmed that the ban of the burkini is not justified in the name of the public order by the risk of public harm invoked by certain mayors. And this ban actually infringed fundamental freedoms such as the freedom to manifest one's religious beliefs, the freedom of dress in the public space, the freedom of movement. And although public order is essential, here we see that the freedom of religion is still protected as a fundamental right. And as such, it cannot be limited without a necessary justification. And lastly, about freedom of religion and public service. So here we have a ruling of the Court of Justice of the EU of 2022, in which the court affirmed that a public authority may prohibit or authorize its employees to wear religious or convictional symbols, as long as this decision applies to all its employees without any particular discrimination and without distinction between beliefs. So the court's case law considers that a clause in internal regulations prohibiting the wearing of religious symbols does not constitute direct discrimination, provided that the prohibition is strictly necessary. So this decision is interesting because it could encourage the emergence of laïcité à la française within the EU, since it requires all public service employees, whether in contact with users or not, to adhere to a strict policy of neutrality, excluding all visible religious symbols. So to conclude, we can say that the Charter of Fundamental Rights of the EU is a key document in the EU, especially since it became legally binding, not only to the institutions that had proclaimed it, but also to the member states after 2009, that it affirms the Union's dedication to human dignity, freedom, democracy, and equality. And it's interesting because its innovative grouping of rights transcends traditional distinctions. It addresses modern issues while upholding traditional freedoms. And given the diversity of rights and the intensity of the protection that the Charter can provide, it must be circumscribed both in its scope of application and interpretation, as we saw. And so for this reason, the in concreto appreciation made by the judge on a case-to-case basis must look for a balance between, on one hand, the diversity of the cultures and traditions of the peoples of Europe, and on the other hand, the national identities of member states and the internal organization of public authorities. And this balance is actually very constant in the public debate of nowadays, not only when talking about religious freedom. So this was our presentation on the Charter of Fundamental Rights of the EU. We hope that you found it useful and interesting, and we thank you for your attention.